Hi everyone, the Employment Rights Bill has finally been published, all 158 pages. We're less than 24 hours on and I've not read the whole bill as yet. But what I wanted to do was focus on perhaps the juiciest aspect, which is the removal of the 2-year service requirement for qualifying for unfair dismissal rights. The headline is that 2-year period will go, and that is explicitly contained in the bill. And that it will be replaced by some sort of probationary period and probationary process, which is a little light on the detail in the bill. So I wanted to comment firstly on that and what the bill actually says, and then move on to more expansive provisions in the bill which relate to fire and rehire or fire and replace practices. So the right not to be unfairly dismissed will, as the government says, become a day one right. That has been watered down to a significant extent by the government stating that an initial period of employment, or a probationary period essentially, where an employer can demonstrate a potentially fair reason of capability, conduct, illegality, or some other substantial reason, will mean that an employee will not qualify for unfair dismissal rights. The process to go through to suitably complete a probationary period and dismiss is to be determined by the Secretary of State. And interestingly, the initial period of employment, so the suggested 9-month period for a probationary period, is again subject to agreement and consultation. One surprising element that I've read in the bill is that initial period of employment could, for example, be simply 9 months, and I think that is likely to be the case after consultation. But it could also allow protection where, for example, an employer places an employee on notice of dismissal just before 9 months, and as long as that dismissal does not take effect longer than a further 3 months, the employee will not have protection from unfair dismissal. That is a little bit unusual because I think if an employer wishes to terminate employment, they typically won't have a 3-month notice period for the employee unless they're particularly senior, but also might not want the employee to be working that notice period. But it's interesting to note that potentially that initial period of 9 months could be extended by up to a further 3 months. The more interesting aspect that I found in the bill, which was commented on in the press release a little bit, but took me by surprise in terms of the strength of the section, is on variations to contracts of employment. So this is the government trying to outlaw fire and rehire or fire and replace practices. It is suggesting that it will be automatically unfair, so irrespective of length of service, it can be automatically unfair for an employee to be dismissed where the employee is seeking to vary the employee's contract and the employee did not agree to that variation, or where the reason for dismissal is simply so that the employer can arrange for somebody else to step into their shoes and carry out substantially the same role. And it is written as if there is no service requirement whatsoever, so employers cannot use probationary periods to avoid liability where they want to fire and rehire or fire and replace. There is some concession in that section for the employer. So if the reason for the variation is to eliminate, prevent or significantly reduce or mitigate the effect of financial difficulties, and the employer could not in all the circumstances have reasonably have avoided the need to make the variation, there potentially is a defence to that claim. And in considering whether that has been met, a tribunal is entitled to take account of any consultation carried out, any consultation with trade union, any consultation with any other employee representative groups there might be, anything offered in return, perhaps as a sweetener or some sort of one-off bonus in return for agreeing the variation, and any other matters specified by the Secretary of State. So it does look like one of the focuses of the government is not only on reducing the period of time where employers have flexibility to make decisions about employees, but also specifically if the reason for termination is purely that the employer wants to force through a variation of contract or replace the worker with somebody else, it looks like there will be a layer of additional protection for them. We will be putting out a lot more content on the changes generally. As I say, 158 pages makes for some detailed reading and assessment of what's to come. The government did confirm that it's highly unlikely, and I think impossible, that any changes to unfair dismissal will come in before autumn 2026, so there is a lot of time to prepare. But if you need anything on this or employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.